But make no mistake, it will disrupt their lives for the year or years that they're in that position. Hi, Jeff Versace, the Plain English Attorney, and welcome to the video. Today we are going to talk about a will versus a trust. When it comes to estate planning, what you do with your estate is wide open. However, there are only two heavyweights when it comes to how you pass along a coordinated estate. You are either using a last will and testament or a revocable living trust as the base of your plan. But which one is best? We're going to go 10 rounds on this one to see who goes the distance and which one comes out on top. In one corner, we have the court-tested and even more court-tested choice of probate attorneys everywhere, the massive law firm moneymaker, the renowned and notorious rating legal document on everyone's lips, the last will and testament. In the other corner, we have the court sidestepping king of dodging and weaving around probate, the cost-saving, time-reducing, contest-busting challenger of estate planning, the scrappy underdog of the plan-ahead world, the Revocable Living Trust. For this match, we'll be going 10 rounds and giving you the blow-by-blow between the last will and testament and the Revocable Living Trust to see which is going to come out on top as the better planning document to go the distance for you and your loved ones. Before we dig into it, here is some simple definitions of a last will and testament and a revocable living trust. The last will and testament, according to Investopedia, a last will and testament is a legal document that communicates a person's final wishes pertaining to their assets. It provides specific instructions about what to do with their possessions. It will indicate whether the deceased leaves them to another person, a group, or wishes to donate them to charity. Continuing with Investopedia, it lists some key takeaways. Having a last will and testament gives you some control over what happens to your assets after you die. If you die intestate or without a will, your estate, including the distribution of all assets, is settled by the courts. If parents with children die without a will, the courts will appoint a guardian for those who are minors. And trusts and final accounts, including life insurance policies with named beneficiaries, do not have to pass through the probate court. So that's an important distinction there. As for a revocable living trust, Investopedia also has a definition and some key points. A revocable trust is a trust whereby provisions can be altered or canceled depending on the wishes of the grantor or the originator of the trust. During the life of the trust, income earned is distributed to the grantor, and only after death does property transfer to the beneficiaries of the trust. A revocable trust is helpful since it provides flexibility and income to the living grantor, also called the trustor. Provisions of the trust can be changed, and the estate will be transferred to the beneficiaries upon the trustor's death. And the key points, again, listed by Investopedia. Trusts are created by individuals assigning a trustee to manage and distribute the assets to the beneficiaries after the owner's death. Revocable trusts let the living grantor change instructions, remove assets, or terminate the trust. Irrevocable trusts cannot be changed. Assets placed inside them cannot be removed by anyone for any reason. So that's irrevocable. Revocable trusts allow beneficiaries to avoid probate court and guardianship or conservatorship proceedings for what's inside the trust. However, revocable living trusts have upfront costs, involve many steps to fund, and don't exempt the owner from needing a will. Now, what Investopedia didn't emphasize is that will, it's called a pour-over will, meaning if something inadvertently goes through probate, the will only states that the trust is the beneficiary and therefore doesn't duplicate the terms of the trust, letting the public know who your beneficiaries are. So now, let's get ready to rumble. And for round one, we have setup cost. A last will and testament duking it out head to head with a revocable living trust on setup costs, this is clearly going to favor the will. A revocable living trust is usually a lot more expensive upfront because all of the terms governing how the trust is to be read, interpreted, and executed should be clearly laid out inside the trust so that it doesn't have to rely on state law. If it did, then it's an open invitation for a judge to be brought in to interpret the provisions in the courtroom and therefore adds to the cost to settle. If the estate is to be handled with as little government interference as possible, then as many questions as possible should be answered ahead of time inside that trust document. On the other hand, a last will and testament has relatively few terms because it relies completely on the probate court system, state statutes, and even court rules for interpretation. And this means more expensive attorney's fees on the back end, but for the upfront costs, it's wills 1, trust 0. So this round definitely goes to the last will and testament. Round 2, ease of changes. When it comes to making changes to your estate plan, the advent of computers and word processors have made it easy across the board to update a last will and testament and a revocable living trust.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
When an attorney is well-versed in their own documents, there should be hardly any difference in the costs of making changes, provided there isn't some major upgrade to the overall documents. So this round should really be considered a draw, giving half a point to each. So the score right now after 2 rounds is 1.5 to wills and half a point to the trust. Round 3, ease of understanding. Okay, when you're looking at the documents of a last will and testament and a revocable living trust, the advantage clearly goes to the last will and testament. After all, a will is typically less than 10 pages, while a solid revocable living trust is probably more than 60 pages at a minimum. As I mentioned before, the trust has to be as specific as possible regarding a whole host of likely and unlikely contingencies and spell everything out so it doesn't have to rely on state laws in the courts to make interpretations. However, the best way to look at the ease of understanding is comparing how a bicycle works compared to an automobile. When looking at a bike, there are the pedal turns, causes the wheel to move forward. The handlebars steer the bike. And look, it's easy. The brakes make it slow down. It's easy to understand that. Comparing that to understanding how an internal combustion engine works along with a computer-driven power system and this complex braking systems, look, it's just a lot more complex and more difficult to understand. However, remember the goal here. You're traveling from, say, Raleigh, North Carolina to Miami, Florida. Going by bicycle instead of a car just because the bike is easier to understand doesn't make the trip better. It doesn't make much sense. But nonetheless, on this whole ease of understanding, this round goes to the will, making the count wills 2.5 points to half a point for the trust. Now we're on to round 4, the allocation and distribution. When it comes to identifying beneficiaries to get an inheritance, a will and trust appear to be exactly the same. After all, both documents list the beneficiaries, what assets or percentages of an estate they get, and even age limits for underage beneficiaries. However, when it comes to how much and how quickly the beneficiaries receive that inheritance, the advantage has to go to the revocable living trust for one big reason. The government probate court process doesn't need to be right there in between your estate and the beneficiaries. That process does not need to be followed. The next 2 rounds are going to explain a little more about why the last will and testament may be on the ropes from here on out. So the count is wills, 2.5 points to 1.5 points for the trust. Going on to round 5, estate settlement costs. By its very nature and design, the probate court process is extraordinarily detailed and is often criticized as convoluted. And that's exactly what you get with the last will and testament. Because of this, an admittedly older AARP study showed that probate costs somewhere between 8 and 10% of an estate. My own experience broadens that a little. It's probably somewhere around 4 to 10% of an estate. And it can be more. In fact, many attorneys and law firms will offer to be the executor or the administrator of the estate for a flat 5% of the value of the probate estate. While the families of clients may consider that cost a bargain if they don't have to deal with the unfamiliar probate court process, my clients during the planning stage, they think paying 5% of everything they've worked their whole life to accumulate just to handle court paperwork that's not really necessary, that's just ridiculous. Since a revocable living trust avoids probate and therefore those costs, the advantage is clearly with the revocable living trust in this round. Tying it up, wills 2.5 and a trust 2.5. Round 6, estate settlement time. Once again, we do have a clear advantage in this round, and it's with the revocable living trust. When it comes to estate settlement times, probate generally takes about 6 months to a year and a half, and it can be more. In fact, an estate going 2 or more years, it's not really rare. In addition to the difficulties of balancing everything down to the penny and multiple reports, filings, and with exacting documentation backing all of it up, there are already built-in minimum time frames when it comes to probate. One of these is if you end up having to publish a notice to creditors in the newspaper, it's got to be there, and only 3 months later can you proceed with closing out the estate. So you've got that built-in time frame. At that point, the claims are cut off. You can go to then a final accounting. A final accounting isn't going to be accepted until that term is up. And this is not to mention the often different but no less abundant paperwork that financial institutions require when liquidating accounts for a deceased person. While records still need to be kept with the revocable living trust, the less rigid procedures mean the trust can be settled much more quickly. So this round, another clearly one that goes to the trust. So that's wills 2.5, trust 3.5. Round 7, privacy. Something most people don't realize is that probate is an actual court process that is open to the public. Because probate inventories require a copy of the last will and testament, a list of all the assets valued as of the date of death, the names, the ages, addresses of the beneficiaries, all of that information is now open to the public. Many years back, a client of mine said he had a Friday afternoon question for me. This was his way of saying, okay, I'll ask it if you don't bill me. I said, all right, fine. He said, his dad died in Michigan 4 months ago. Does that have anything to do with him receiving all of these mailings from Mercedes and BMW? Yeah, it is. They saw that he was inheriting a bunch of money and they wanted to be first in line to help him spend it. Isn't that great? Isn't that wonderful? How nice of them. On the other hand, with a revocable living trust, even if a few assets end up going through probate, the only name and address listed is that of the trustee, and it only lists those probate assets. So at the end of the line, no one knows exactly who's receiving the inheritance and where they live and what their ages are. So it just has much more of an advantage with the revocable living trust for maintaining that type of privacy over the estate. So this is a big round for the trust. So we're at wills 2.5 and trust 4.5. And now we move into this critical round 8, and we can see, is the trust going to pull ahead? So round 8, maintenance costs and time. While it seems that keeping up a revocable living trust would be more work than updating a last will and testament, the fact is it is a draw, because a will only applies to assets that end up in probate. The joint owners with pay on death beneficiaries on accounts, they need to be updated if the plan needs to be updated every bit as much as assets need to be coordinated with the revocable living trust. So when assets change, that time is basically equal. So this round is a draw, making the score wills 3, trusts 5. Round 9, let's see. This is the critical one. Are we going to end up with a tie? Round 9, ease of contesting an estate plan. Depending on the family situation, this one may be an immediate knockout blow. A trust is much harder to contest than a last will and testament because of the way probate is generally set up, which can vary state to state, but in general, if someone is contesting a will, all it takes is to file a few forms and the whole estate comes to a grinding halt until that issue is settled. So the main factor in this being easily contested is a lot of attorneys who would take even a weak case without being paid up front because they know that a court is very likely to make sure that all of the attorneys get paid out of the estate, as long as that case isn't really 100% frivolous. On the other hand, contesting a trust involves filing a civil lawsuit, so it's not in that probate court system. And those court proceedings make it a lot harder for attorneys to get paid by the other party. And this is why many attorneys would insist on a retainer before even getting to work on this contest in contesting a revocable living trust. And one thing that I have found in my many years of doing this is people who want something that they're not entitled to rarely want to put up their own money to try to get it. So the score in the 10th round is now wills 3 and trusts 6. Moving on to the final round, round 10, settlement agent hassles. So probate is a long, time-consuming, and often frustrating process. And when you name executors in a last will and testament, that is what you're signing them up for. I have often commented that being an executor is the worst part-time job you'll ever have. Sure, the executor gets paid, and it can be kind of lucrative if they're doing all of the work on their own, but make no mistake, it will disrupt their lives for the year or years that they're in that position. I remember one client who, upon finding out just how much work his estate was likely to be, he still went with the last will and testament and named his younger son as the executor because it would be a good learning experience for him. By far, it is a lot less work for a successor trustee to handle the final bills, handle the taxes, and distribute the assets to the beneficiaries through a revocable living trust. And it can wrap up with a lot less time and disruption in the trustee's life. This final round goes to the trust, and the score at the end of the match, wills 3, trust 7.
Finish it!
And the new heavyweight champion of estate planning, the Revocable Living Trust. I hope you found this video informative, but if you do want to learn more about estate planning, revocable trusts, and avoiding probate, then please check out the free program at freetrustcourse.com. Again, that is freetrustcourse.com. And if you would like to support our efforts to keep this information out there free while enjoying some of the extra perks that come along with it, then please consider joining the channel as a paid membership. It really does make a difference. So with that, I'll close with what I tell my clients. Please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.